But I also think that he is innocent of these recent accusations against him. 3 reasons why. Number one, innocent until proven guilty. That's the basic fundamental principle, not only in secular justice systems, but also in Islam.
Yeah, no, it doesn't work that way. Let's go through this and debunk it.
But I also think that he is innocent of these recent accusations against him.
Notice he says that he actually thinks he is innocent of the charges, and not simply that he should be treated as innocent. That's the point. If he said we should consider him innocent until more evidence comes in, then we wouldn't have a problem. But since he said that he thinks he is innocent and he cites the presumption of innocence as proof, now we have an issue.
3 reasons why. Number one, innocent until proven guilty. That's the basic fundamental principle, not only in secular justice systems, but also in Islam.
A shocking blunder. Innocent until proven guilty does not mean you are actually innocent. As stated by John Tumulty, Criminal Defense. For that reason, criminal defendants and those close to them should understand that the concept of innocent until proven guilty is symbolic. In reality, no defendant would be required to stand trial unless a police officer, crime victim, or prosecutor believes he or she is guilty of committing the crime. The government must show it has sufficient evidence or probable cause to conclude that the defendant committed a crime. After probable cause is accepted, the accused isn't necessarily treated as though he or she is innocent of the crime and may be remanded to jail with the court's approval. Similarly, as stated by Kevin Sear, prior to obtaining a search warrant, an officer must possess a belief that an offense has been committed and that evidence of that offense exists at a given location. While the search warrant standard does not require a belief of a specified party's guilt, oftentimes such a belief will be readily implied, if not directly stated, in an information to obtain a search warrant. This is not particularly upsetting. Who would want the police to be able to take action against persons they thought were innocent? To cite one more source, in the case of R. and Secretary of State for Justice, 2019 UKSC 2, the court stated, "In English law, as in many other legal systems, it is not the function of criminal proceedings to determine innocence." As Lady Hale stated in Adams, para 1 and 16, innocence as such is not a concept known to our criminal justice system. We distinguish between the guilty and the not guilty. A person is only guilty if the state can prove his guilt beyond reasonable doubt. There are not in Canadian law two kinds of acquittals, those based on the Crown having failed to prove its case beyond a reasonable doubt, and those where the accused has been shown to be factually innocent. We adopt the comments of the former Chief Justice of Canada in the Lamer Commission of Inquiry pertaining to the cases of Ronald Dalton, Gregory Parsons, Randy Drukin, Annex 3, p. 341. A criminal trial does not address factual innocence. The criminal trial is to determine whether the Crown has proven its case beyond a reasonable doubt. If so, the accused is guilty. If not, the accused is found not guilty. There is no finding of factual innocence, since it would not fall within the ambit or purpose of criminal law. So what does all this mean? It means that the presumption of innocence is a legal standard, not an epistemological claim about reality. It does not mean the person is actually innocent. It means the state must treat them as not guilty until it can prove otherwise. That's a procedural safeguard, not a factual statement. So when someone says, "I think he is innocent because of the presumption of innocence," they are misapplying the principle entirely. They are turning a legal presumption into a statement of belief, which it is not designed to be. To illustrate, if we had 500 witnesses and video footage all showing a person committing a robbery, but the accused pleads not guilty, he is still presumed innocent under the law. That does not mean anyone thinks he's actually innocent. It just means the court must proceed under that presumption until guilt is formally established. Everyone, including the judge and jury, may be confident the person is guilty, but the process must still unfold properly to prevent systemic abuse. This legal fiction exists for a reason, to protect the innocent from being railroaded, not to assert the factual innocence of every accused person. If the burden of proof were not so strict, innocent people would be punished far more often. If courts could just assume people were guilty without having to prove it, that would send innocent people to prison. So circling back, when someone says, "I think he is innocent," and cites the presumption of innocence as their reason, they are no longer making a neutral, procedural point. They are making a positive claim about truth and reality, and for that claim, they need evidence, not a misused legal doctrine. Even in Islamic jurisprudence, which also upholds principles of due process, the idea of presumption of innocence operates as a legal default, not a declaration of metaphysical innocence. It is a protection, not a confirmation. Therefore, To believe someone is factually innocent based solely on the presumption of innocence is a category error. In summary, the phrase innocent until proven guilty is about how the justice system must act, not about how the public must think. If someone wants to claim innocence as a belief, they must justify it with evidence, not with a procedural safeguard designed to ensure fair trials, not to settle matters of fact. A few more critical clarifications are necessary on this topic. First, understand that the presumption of innocence applies within the courtroom, not outside it. In a legal trial, it serves as a procedural protection to ensure a fair process. But in day-to-day life, people are not bound by courtroom standards. While it's wise to give others the benefit of the doubt in ambiguous situations, it is also entirely rational to form judgments when overwhelming evidence is available, especially when something is caught clearly on video. You do not need a judge's verdict to trust your own eyes and common sense in such cases. That said, when the evidence is unclear, jumping to conclusions is dangerous. Merely being accused of something does not make someone guilty. False accusations are a real problem, and entire reputations can be destroyed long before any investigation concludes. Even when the truth eventually comes out, the damage is often irreversible. So exercise caution. Withhold judgment unless the evidence is strong. At the same time, a guilty verdict doesn't necessarily prove guilt, and a not guilty verdict doesn't necessarily prove innocence. Legal systems are powerful, but they're not perfect. Mistakes can happen. Sometimes justice is obstructed by corruption, bias, incompetence, or missing evidence. However, and this is a crucial point, a criminal conviction usually reflects overwhelming evidence. It takes tremendous effort from police, prosecutors, and juries to secure a conviction beyond a reasonable doubt. That is not something that happens casually, so be wary of every criminal claiming they were framed or set up. While miscarriages of justice are real, they are rare exceptions, not the rule. Don't be naive. Learn to balance healthy skepticism with realistic probabilities. In the case of Tate, there are literally videos of him confessing to immoral and potentially illegal behavior. If he just shut his mouth about his evil acts, he probably wouldn't be in the situation that he is in. And now that you understand the basics of the presumption of innocence and how it operates both legally and socially, I hope you can apply this knowledge with discernment. Thanks for watching. Please like, subscribe, and share this if you found it helpful.